Hello everyone, welcome to this channel. Now we are going to read Article 16 of our Indian Constitution, Part 3 of the Fundamental Rights. So 16, Clause 1 states that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Clause 2 states no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for or discriminated against in respect of any employment or office under the state. The clause 3 states that nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the Government of India or any local or other authority within a state or union territory any requirement as to residence within that state or union territory prior to such employment or appointment. So, clause 4 nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which in the opinion of the state is not adequately represented in the services under the state. 4a. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of posts in the services under the state in favor of the scheduled castes and the scheduled tribes, which, in the opinion of the state, are not adequately represented in the services under the state. Nothing in this article 4b. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under clause 4 or subclause 4a as a separate class of vacancies to be filled up in any succeeding year or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50% reservation on total number of vacancies of that year. So clause 5 nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination. Clause 6 has been added to the Article 16, which reads as nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes mentioned in the clause 4 in addition to the existing reservation and subject to a maximum of 10% of the posts in each category. So here this section talks about is reservation applicable by the SCs, STs, OBCs, and the EWF reservation, which are introduced in 2019 by 103rd Amendment. So yes, we will simplify this article by noting the principles embodied in the Article 16. The term reservation means giving preferential treatment to marginalized section of society in employment and access to education, and it is a form of positive discrimination meant to promote equality among marginalized sections so as to protect them from social and historical injustice. Article 16 guarantees equality of opportunity to all citizens in matters related to employment in the public sector. The provisions of equality in Article 16(1) is only applicable to the employment or offices held by the state. However, the state is free to lay down the requisite qualification for the recruitment of employees for the government office services. Provisions of equality in Article 16, Clause 1 is only applicable to the employment or offices held by the state. However, the state is free to lay down the requisite qualifications for the recruitment of employees for the government services. The expression matters relating to employment or appointment includes all matters in relation to the employment, both prior and subsequent to the employment. Thus, the term guarantee in Article 16, Clause 1 covers initial appointments, promotions, terminations of employment, matters relating to salary, periodical increment, leave, gratuity, pension, age of superannuation, etc. Article 16, the clause 2 lays down that lays down the grounds on which the citizen should not be discriminated against for the purpose of employment or appointment to any office under the state. The prohibited grounds of discrimination are religion, race, caste, sex, descent, place of birthplace, residence, or any of them. Article 16, clause 3 is further explanation to Article 16, clause 2, which forbids discrimination on the ground of residence. This clause empowers Parliament to make laws prescribing residence as a criteria for employment. Article 16, clause 4 expressly provides for the reservation of appointments or posts in favor of any backward class of citizens, which, in the opinion of the state, is not adequately represented in the services under the state. 16.4 is not an exception to Art 16.1. On plain reading of this clause 16.4 seems to be an exception to the rest of the provisions of Article 16, but the Supreme Court in the state of Kerala versus N.M. Thomas, year 1976, opined that clause 4 of Article 16 is not an exception to clause 1 of Article 16. Further, in Indra Sahni versus Union of India, AIN 1993, Supreme Court held that Article 16 subclause 4 is not an exception to Article 16.1. Rather, it is a facet of equality of opportunity guaranteed in clause 1 of that article and an effective method of realizing and implementing it. 16 subclause 5 says that religious qualification can be prescribed for incumbent of religious institutions. This is an exception to the general rule laid down in Clause 1 and Clause 2 of Article 16, which forbids discrimination in public employment on the ground of religion. Article 16.6, which was added by Constitution in 103rd Amendment Act, I will provide the link in the description, to provide reservation to people for economically weaker sections in government posts. This reservation is in addition to existing reservation in appointment and subject to a maximum of 10% of the total seats in each category. And the quantum of reservation is decided in M.R. Balaji versus the state of Mysore, AIR 1963. Mysore government issued an order where reservation was provided in the following manner. Backward classes 28%, more backward classes 20%, SC, ST 18%, and other reservation 2%. Total 68% seats were reserved in engineering, medical, and other technical institutes. The Supreme Court held that reservation contemplated by Article 15.4 and 16.4 must be within reasonable limits. Generally speaking, it should be less than 50%. The court said that Article 16.4 provides that the state can make special provision and not exclusive provision. The reservation of 68% is gravely against Article 16.4. The court said that this 16.4. The court said that the state would not be justified in ignoring altogether advancement of the rest of the society in its zeal to promote the welfare of backward classes. National interest would suffer if qualified and competent students were excluded from admission in the institution of higher education. In Devdasan versus Union of India, year 1964, the government reserved 17.5% seats in central services for reserved categories but provided for carrying forward of unfilled seats for next years. In the instant case, by virtue of this provision, 29 out of 45 seats were reserved. The court invalidated the carry forward rule as it exceeded 50%. In the state of Kerala versus N.M. Thomas, AI in 1976, the important question which came up for consideration to the court was whether it is impermissible to give preferential treatment to SCs and STs under Clause 1 of Article 16. Outside the exception of Clause 4 of Article 16, the court held that A. Article 15.4 and 16.4 are not exception, but they are emphatic assertion and direction to take affirmative action. B. It confers discretionary power to make reservation but not mandatory. C. It upheld carry forward rule and accepted the above reasoning considering the SC/ST population and their representation in the state services comparatively was much below. They said that to bring equality, state could make reservation up to any extent. In Indra Sahni versus Union and others versus Union of India, year 1993, it was held by a nine-judge bench of Supreme Court that the reservation contemplated in Article 16, subclause 4, should not exceed 50% of the appointments in a grade, cadre, or service in any particular year. It is only for extraordinary reasons that this percentage may be exceeded. However, every excess over 50% will have to be justified on valid grounds to be specifically made out. The adequacy of representation is not to be determined merely on the basis of overall numerical strength of the backward classes in the services. For determining the adequacy, their representation at different levels of administration and in different grades has to be taken into consideration. It is the effective voice in the administration and not the total number which determines the adequacy of representation. This was said in Indra Sahni and others versus Union of India, AI 1993. In Chebrolu Leela Prasad Rao versus State of Andhra Pradesh, AI 2022, the Constitution Bench comprising Justice Arun Mishra, Indra Banerjee, Vineet Saran, M.R. Shah, and Aniruddha Bose held that 100% reservation of teachers belonging to scheduled tribe category at schools situated in scheduled areas is unconstitutional. So, basis of the reservation, we should talk about the basis of reservation. In M.R. Balaji versus the State of Mysore, AI 1963, it was held that while dealing with the questions as to whether any class of citizens is socially backward or not, it may not be irrelevant to consider the caste of a class as a class of citizens. Although it is not logical to make caste the sole basis of classification, but caste is also a class of citizens. Caste furnishes a working criterion and it is also the primary index of social backwardness. This was stated in M.R. Balaji versus State of Mysore by the Supreme Court. Furthermore, in Indra Sahni and others versus the Union of India, AI 1993, which is also known as the Mandal Commission case. Indra Sahni case is known as the Mandal Commission case. Deals with reservation in public employment and it provides that number one, backward class is not defined in the constitution and even a caste may also constitute a class. Second, the backwardness contemplated under Article 16.4 is mainly social. Third, income or extent of poverty can be taken as a measure of social advancement, and on that basis, the creamy layer of a given caste can be excluded from getting benefit of reservation. Fourth, the reservations contemplated under Article 16.4 should not exceed 50%. Fifth, carry forward of unfilled vacancies of last years is allowed but subject to 50% limit. Sixth, there should be no reservation in promotion. Reservation in appointment of post under Article 16.4 is binding only upon initial appointments and cannot extend to provide reservation in matter of promotions. The above decision of the Supreme Court has been nullified bit by successive amendments made by Parliament, which are as follows. The Constitution, 77th Amendment Act 1995. In Indra Sahni case, it was said by the Supreme Court that there will be no reservation in promotions, but 77th Amendment in Constitution inserted Clause 4A in Article 16, as you can see on the screen, which provides that there will be reservation in promotion for scheduled castes and tribes as long as the state is of opinion that they are not adequately represented in state services. Second, the Constitution's 81st Amendment Act 2000. In Indira Thani case, it was held by Supreme Court that the reservation quota shall not exceed 50% and therefore a cap or ceiling limit of 50% applied to current as well as to backlog vacancies was imposed on reservation. But although through 81st Amendment in Constitution, Clause 4B was inserted, Clause 4B was inserted in Article 16, which put an end to the ceiling limit and states that the unfilled vacancies of the previous years, which could not be filled due to non-availability of eligible candidates belonging to scheduled castes and scheduled tribes and backward classes, will be considered as a separate class and will be filled up in the succeeding year or years. This is also known as the carry forward rule. Notice carry forward rule. The Constitution 85th Amendment Act 2001, through this amendment, the words in matters of promotion with consequential seniority to any class were substituted in place of in matters of promotion to any class. In Article 16.4a, it provides that the person of reserved category promoted earlier will be treated as senior to general category employee, even if reserved category employee has been appointed later on. In M. Nagaraj versus Union of India, AI 2007, the petitioner challenged the constitutional validity of 77th Amendment Act, introducing Article 16(4)(a), nullifying a number of decisions, and the 81st Amendment Act 2000, inserting Article 16(4)(b), including promotion and reservation. The five judges Constitutional Bench of the Supreme Court, headed by CJI Sabharwal, unanimously held that these amendments do not violate the basic feature of the Constitution. These are enabling provisions and only apply to SC and ST. They do not obliterate constitutional requirements such as 50% ceiling limit in reservation, creamy layer rule, and post-based roster subclassification between OBC and on one hand the SC STs on the other hand, as held in Indra Sawhney's case. They do not alter the structure of equality courts, therefore, they are not beyond the amending power of Parliament. The Supreme Court laid down three conditions for promotion of SCs, STs in public employment, which are enumerated as following. Number one, the three conditions. Number one, the government cannot introduce a reservation quota unless it proves that the particular community is backward. Number two, it has to be proved that they are inadequately represented and it should be based on quantifiable data collected by the government. Number three, it is further to be proved by the government that providing reservation in promotion would not affect the overall efficiency of public administration. Supreme Court in this case had reversed its earlier stance in Indra Sawhney case, in which it had excluded the creamy layer concept on scheduled castes and scheduled tribes, and in this case, the court extended the creamy layer principle to scheduled castes and scheduled tribes. The Maratha reservation, the Maharashtra government constituted Backward Class Commission in June 2017 to study social, financial, and economical educational status of Maratha community. The commission submitted its report in November 2018. In the same month, Maharashtra legislature unanimously passed a bill proposing 16% reservation in educational and government job for Marathas. The High Court upheld validity of Maratha reservation, but based on recommendation of State Backward Class Commission, they reduced the quota to 12%. And in Dr. Jayashree Lakshman Rao Patil versus the Chief Minister and others 2021, the five-judge Constitutional Bench of the Supreme Court declared that the Maratha quota law as unconstitutional. It quashed the Socially and Economically Backward Classes Act 2018. It was also against Indra Sawhney judgment that which fixed reservation limit to 50%. The Supreme Court held that separate reservation for Maratha community violated the Article 14 and Article 21. So, furthermore, we talk about the Jat reservation, the movement, if you remember, in 2015. In Ram Singh versus Union of India 2015, for the various reasons, we cannot agree with the view taken by the Union government that Jats in the nine states in question is a backward community, so as to be entitled to inclusion in the central list of other backward classes for the states concerned. The view taken by the NCBC to the contrary is adequately supported by good and acceptable reasons, which furnished a sound and reasonable basis for further consequential action on the part of the Union government. Accordingly, the aforesaid notification, including the charts in the central list of other backward classes for the states of Bihar, Gujarat, Haryana, Himachal Pradesh, Madhya Pradesh, and city of Delhi, Bharatpur, and Dholpur districts of Rajasthan, Uttar Pradesh, and Uttarakhand is set aside and quashed. Creamy layer principles is applicable on scheduled castes and scheduled tribes. This was said in General Singh versus Lakshmi Narayan Gupta, 2018. While refusing to refer the matter to a larger bench, the bench of Supreme Court held, the bench of Supreme Court ruled that requirement of collecting quantifiable data by state on backwardness of scheduled castes and scheduled tribes while granting quota in promotions as laid down in Nagraj verdict is invalid and held that the states only need to show the inadequate representation of scheduled castes and scheduled tribes with the help of appropriate data while granting reservations to them in promotions. The Supreme Court further stated that socially, educationally, and economically advanced cream of scheduled castes, scheduled tribes community must be excluded from the benefits of the reservation in government services in order to transfer quota benefits to the weakest of the weaker individuals and not to be snatched away by the members of the same class who were in the top creamy layer. So, affecting the next topic is consequential seniority. In BK Pavitra and others versus Union of India AI 2020, the Supreme Court upheld the constitutional validity of Karnataka extension of consequential seniority to government servants promoted on the basis of reservation to the Postal Civil Services of the States Act 2018, which provided for consequential seniority to persons belonging to the scheduled castes and scheduled tribes promoted under the reservation policy of the state of Karnataka. Prospective effect of M. Nagaraj judgment in General Singh versus Lakshmi Narayan Gupta 2022. The Supreme Court up General Singh versus Lakshmi Narayan Gupta AIA 2018, but 2022 is another reference LLCC 94, LLSC 94. The Supreme Court declared that its judgment in M. Nagaraj and others versus Union of India AIA 2007 SC 271 will have only prospective effect. It was held that making the principle laid down in M. Nagaraj effective from the year 1995 would be detrimental to the interests of number of civil servants. This is also to avoid chaos and confusion that would ensue from its retrospective operation. Reservation in jobs promotion is not a fundamental right. Article 16.4 is not a fundamental right. It is an enabling provision which gives discretion to the state to make special provision and does not impose any duty on state. Under Article 16.4, there is a twin test for reservation. As you can see, firstly, there should be a backward class of citizen. Second, there should not be adequately represented in the services under the state. Article 6, for achieving equality, it provides for reservation to backward class in public employment. Article 16.4a allows reservation to SCs and STs in promotions as long as the government believes that they are not adequately represented in government services. In Mukesh Kumar and others versus the state of Uttarakhand, AIA 2020, the Supreme Court has stated that there is no fundamental right which inheres in an individual to claim reservation in promotion. No mandamus could be issued by the court directing the state government to provide reservations, as Article 16 surplus 4 and 16.4a do not provide a fundamental right. That is why the courts cannot issue direction to the state government to provide reservation. However, if the state government wants to exercise its discretion and provide reservations, it would have to first collect quantifiable data showing inadequacy of representation of that class in public services. It was held in Mukesh Kumar and others versus the state of Uttarakhand AI 2020. Now coming to the case of in the state of Kerala versus Lisamma Joseph AI 2021. The Supreme Court held that persons with physical disabilities have right to reservations in promotions also. While approving the High Court judgment, the Supreme Court held that number one, the 1995 Act recognizes right to reservation in promotion. Number two, identification of posts for reservation as per Section 32 of the 1995 Act is a prerequisite for appointment, but appointment cannot be frustrated by refusing to identify posts. Number three, the absence of provision for reservation in the recruitment rules will not defeat the right of a PWD as such right flows from the legislation. Number four, reservation to promotion can be given to a PWD even if the person was not originally appointed in the PWD quota. Thank you. This was all about the Article 16 of our Indian Constitution. Thank you.